ನೀರಂದ್ರೆ ಮೀನ್ ನೀರ್ Good morning. ఎవరు కష్టపడతారు ఏంటి మా గ్రూప్ ఏం చెప్తున్నా కానీ అమ్మని ఫ్రెండ్లో Highlights. Who's on the other side? No objection? 43 at the request of the council for the department enabling them to file counter is this case on the 31st of January, the interim relief earlier granted to continue.
Hello, item number 45 and 46. I am appearing on behalf of the petitioner council. It's coming up for my reply affidavit first. My lords may extend it by 2 weeks. My lords may grant 2 weeks time.
Apply for?
Reply for the counter affidavit. The applicant has already filed their counter to file my reply affidavit. 45, 46. On behalf of Vasco.
For rejoin. 45 at the request of the council for the petitioners enabling them to file rejoinder to the counter file by the department. Is this case on 31st of January? The interim relief earlier granted to continue.
Is on item 41. But after that, what is not? Because there is also filed 2 weeks.
Year number of cycle.
For service filed.
Year number I think.
You filed it.
Again, year. We get 2 weeks.
You are appearing for the claimants. Appellant claimants. Insurance company. Awaiting the appearance of the respondents. Let the matter be taken up for hearing on the 23rd of January. Yes.
56, 71.
63.
63. Yes.
Repetition, the office haven't been served to the respondent. We are paid for respondent 3 and 4.
It appears to be a batch matter.
Yes, sir. 63 and 66.
No, not just 63. It starts from 53 onwards. 53 to 67.
And paid for matters number 63 and 66.
For the respondents.
For the
Third respondent.
third respondent and fourth respondent in petition number 1960.
The question is,
For seven.
who appears for the petitioner?
Senior advocate Keshav.
You'll have to wait then. If there is a batch matter, let the number reach, then we'll consider.
Item 72, 87. Item 88, 111. Item 112, 133. Item 134, 146. Item 147, 161. Item 176. Item 177 to 200. Item 211 to 229. Item 230 to 256. Item 257 to 270.
Yes. What is the matter? Yes, Mr. Counsel. Yes.
Let me please, Your Lordship. That is item number 1 for which has been listed for orders, my lord, today.
Just 1 second. There's one out of turn mentioning being made.
My lord, subject to my lord's kind leave, my lord. I am Jilani here, my lord.
Yes, please.
My lord, this WP 16496 2023. My
Yes.
lord, directed to post on 30th, my lord, October. Today it has not been listed. My lord, it pertains to, my lords are aware. The issue is, my lord, settlement OTS, then thereafter some GST arrears also directed to be paid by the dealer. Your lordship may kindly have it tomorrow. My 30th it should supposed to be listed. It was not listed. My colleague will be placing the slip, my lord. Your lordship may kindly.
It was not listed on 30th.
Yes, my lord. It was not listed on 30th, my lord.
Just check it. Why was it not listed?
16496 of 2023, my lord.
You have it tomorrow.
Much appreciated.
119.
Yes, Mr. Shivram.
Yes, my lord, my lord. May it please, Your Lordships. But this is from item number 1 to 19. But there are both the appeals by the department and appeals by the necessary. Both of them, my lord, are covered well against by Your Lordship's orders, my lord, which is pronounced on 2/11/2023. But item numbers which I have filed starts from serial number 2, 4, 10, 13, 14, 15, and 16.
Can you just repeat that?
Lord,
Already mentioned.
Lord, item number 2, 4, 10, 13, 14, 15 and 16 are my appeals, my lord. Lord, the only issue, my lord, is whether the bad debts, my lord, can be whether the chit fund, foreman dividend, lord, can be claimed an exemption, my lord, on the principles of mutuality. Lord, that is covered, my lord, by the earlier judgment in ITA number 296, etc., batch of 2006.
No, last week we have disposed of.
Yes, my lord. Last week on 211, my lord, your lordships have disposed of. But that is ITA number 324 of 2006, 262 of 2007, 148 of 2008, 309 of 2019.
Whether the order is uploaded?
Order is not yet out, my lord. It was disposed of on 211, my lord. These are all my appeals, my lord. Lordships are having the earlier order, my lord, of this honorable court.
No, we are told that it has still date not been uploaded.
Yes, my lord, it's not been uploaded. But that is, it starts with ITA number 262 of 2007 and 148 of 2008, my lord. That's a lead matter. That was listed on 211.
Yes.
Yes, my lord. The same issue, my lord, entire of, in fact, in my batch of cases, only issue is in respect of the claim of the foreman dividend on the principles of mutuality.
In this you said this is a bad debts.
No, my lord. As far as my appeals are concerned, my lord, the assessee's appeals are concerned, my lord, the only issue, my lord, is whether the appellate tribunal was right in law in rejecting the appellant's claim for an exemption of a chit fund income on the principle of a mutuality on the ground that an appellant is a business concern. And that is the questions of law that has been framed in respect of my appeals, my lord.
That is 2, 4, 10, 13, 14, 15 and 16.
Yeah, exactly, my lord. 2, 4, 10, 13, 14, 15, 16. Item 35 and 36 also, my lord. 35 and 36 also.
Items 35, 36, which are also coming up for admission, but they are same.
Same.
Same. But your lordship's order also covers that issue, my lord, which is the passed on 211.
2, 4, 10, 13, 14, 15, 16.
1, 3, 5, 6, 7, 8, 9, 11, 12, 17, 18, 19, my lord, all are departmental appeals. But the similar issues, my lord, or three issues in respect of bad debts claim, royalty, and also commission on cancelled chits. My lord, all these questions of law were answered, my lord, in the batch of cases and also by your lordships. But the batch of cases what was decided on 9/6/2023. Blood in ITA number 307 of 2005, 92 and 154 of 2006. And your lordship's order, my lord, in ITA number 614 and 630 of 2018. Blood decided on 2/11/2023. And those questions of law, my lord, has to be answered against the department and in favor of the SSC.
What is on 1, 3, 5, 6? Which were admitted by the students on the following substantial question of law. Voting.
Oblige, my lord. Oblige.
It's 420.
Item 20. Take it out.
My lords, connected ITT is coming up. My lords may have this matter.
Tomorrow,
Yes,
at the request of the council, we have done this case tomorrow. Yes,
okay.
for admission.
21. I'm not.
May it please your lordships. Malads, in serial number 21, there's a delay of 157 days in resubmitting the ITT alerts. The delay occurred on 2 counts. First is because the appellant is a resident of US and I was unable to get the documents from him within time. But second, when I received the documents, it was my marriage, Malads, and I was not around for a period of about 1 month. So there was a delay of 157 days in resubmission.
Second is condonable, the first is not condonable. Anyway, this for the department. Who, your counter will be reply. We'll allow it. Word on IN number 1. Item number 1. Item 21. Word on IN number 1, which is an application for seeking condonation of delay in making the representations. For the reasons mentioned in the said earlier and also upon due consideration of the submission made by the Senate Council for the Abla, clear of the considered opinion that a civil case for allowing the application has been made out accordingly. IN number 1 stands allowed the delay of so and so dates in making the representation stands condemned. When do we fix it for admission?
Any date convenient to your lordships.
This is for admission in the next week. Date is put for 21st of November.
Obliged. Obliged.
22. Yeah.
Grounds will not be the same. Word on IN number 2, same order. 99 days in making the representation stands condoned. When do we fix it for admission? Connected. 23rd, 24th, 23rd of November.
So 23. Give this much.
Increase the lords. Payment of bill. People are dismissed as a payment issue. Present the bill. Yesterday, commitment was fitted that notice out.
That is MSCMA number.
MSCMA number 131523. Commitment.
The appeal is admitted for hearing. Let notice be issued to the respondents.
I have only discussed with
Matter will be listed along with MSCMA number 1
1315
1315
523.
23. Some date is given, no. Any date given in that case?
Complete parcel notice was ordered.
So 24. मैं मुझे
Kindly pass on senior is better than
Password.
password. Okay, especially mentioned matter is. Oh,
Day after tomorrow?
Yes.
Is this case for admission on the 10th of?
That's the matter raises under the Income Tax Act, and the challenges to the jurisdiction of the officer in issuing under notice under section 148. This is already covered. Yes, Mr.
The matter?
Yes,
You have
the petition number 3015.
25,
51.
51 again, you are there.
Yes, Mr.
51 same. Yes.
Right.
26.
Without to consent of the petitioner, the compromise is made and the. You have to take it. I agree. I think the architect will be producing the price. So that architect can, whether the particular sign and the council for the credit.
Just seek instructions, you can get through next week. When can we have it?
Next week, you need to
22nd?
Well,
22nd of November. She given appearing for the respondent. Respondent number 3.
sorry,
Please for time to seek instructions. As prayed for, let's just case on the 22nd of November for admission.
so.
Consider on 22nd.
From 27.
Yes,
If there is repetition of this file challenging and assessment orders after the first responsibility under the GST law. Essentially raising threefold ground. First pertains to a violation of the principles of natural justice. There are certain shortcomings in my own conduct, which I also have to explain. Ultimately, an order is passed without reason and without ultimately due notice. Second ground that I have raised my notice is that the order is in fact without jurisdiction. Because my central submission that these are transactions of sale of land and totally outside the purview of GST, which is not being considered, there are no findings on. The third my lord is that the valuation mechanism which the department seeks to adopt for such transactions is in fact being held to be ultra virus members by the Honorable Gujarat High Court. My lord, I think that matter is pending in Supreme Court. What the Honorable Gujarat High Court has done, this so-called valuation mechanism, they have read it down to say it is only optional. My first endeavor, my lords, is to show a natural justice how there has been a violation. My lords, may kindly see the impugned order. I'll first show what is against you. The impugned order is at page 77. The relevant finding, my lords, on the natural justice issues is at page 80, paragraph 7. This is what is against you. My lords, may permit me to read.
yes.
The taxpayer did not file their written reply to the subject show cause notice even after a lapse of more than 1 year, nor attended the personal hearing opportunities to defend their case. The statutory time limit for the SSC to file a reply to the show cause notice is 30 days, as mentioned in the show cause itself. However, following the principles of natural justice, personal hearing opportunities were granted to the taxpayer on 18th May 2023, 1st June 2023, and 26th June 2023 to represent their case. An intimation by this office letters of even number was sent through emails to the registered mail address of the taxpayer as per the office record, which no reply was received in the office. However, the taxpayer by their letter dated 27 June 2023 to this office letter of even number dated 22/6/2023 requested to reschedule the hearing after 20 days. Considering the taxpayer's request, final hearing opportunity was fixed on 18th July 2023. Even upon providing 3 opportunities along with additional opportunity as requested by the personal hearings, they did not avail the same to defend their case, nor furnished any reply to the impugned show cause. Because the issue is not that the reply had been prepared by the petitioner in question. They had engaged a chartered accountancy firm. The reply was indeed prepared, my lord, in 2022 itself. An internal email was also exchanged, my lord, between the consultant and this petition. Because that internal email was at page 264. My lords, I've even enclosed the draft reply which had been prepared. Because this is the email, my lords, may kindly bear with me on the conduct. I'll explain everything. Page 264.
Yes.
Now, the chartered accountancy firm was engaged. My lords, may see the subject of this email. The date is 5th July 2022. In draft reply of SCM, my lords, of MPM Ventures Private Limited. Subject matter, the text is, dear sir, please find attached related file from my side. Kindly go through and provide for any clarification and discussion. Few more points to be made, which can be done at later stage. The reply was at page 265, which was prepared for the 24-page reply.
Yes.
What happened is, my lords, the petitioner was under the understanding that it could be therefore submitted at a later stage, my lords, along with the personal hearing notice. Now, my lords, when it came to the stage of the personal hearing notice, because what had happened is the petitioner had engaged another GST consultant who's also a company secretary, to monitor the GST issue, and their email ID had been used. So what happened, my lords, is the first two personal hearing notices which had come were sent, my lords, to the email ID of this consultant. Because if I may just show those emails, those are, my lords, at page 290 and 291. Because they were at the email ID of the account said agrlaws.com. Because this was not forwarded by the consultant, they have also put it on affidavit. Because they had missed sending these two emails. They sent the third email. And they sent the third email, my lords, containing the PH intimation. Because time was less, my lords, I had made a request that my lords has seen in the impugn knowledge. That we had made a request at the third personal hearing notice stage, requesting for a last opportunity. Because this last opportunity before it was given, because I realized that I'm not getting emails at my correct email ID. Before the third personal hearing opportunity was given to me, the last personal hearing opportunity was given to me on 28th June, my lords. I asked for a change in the email ID. My lords, may see that request, my lords, at page 301. I made an amendment of my registration particular. This was, my lords, on 28th June, before the last page intimation was given. I was ignoring this, my lords, they again sent it to the wrong email ID. My lords, we'll see at 301 is the change of the registration particulars. The date of filing this was 28th June 2023. My lords, will see form description application for amendment of non-code fields in registration particular. And at page 302, man, is the email that I received on 28th June 2022, confirming, my lords, that the email ID has been changed. My lords, may kindly see that at page 302. Now, my lords, the last PH intimation is dated 7th July, much after 28th June. My lords, will find that, my lords, page 306. Note that the second half is the email from the department was dated 10th July. It, however, is still sent to the old email ID. This was forwarded to me only upon inquiries, my lords, from that consultant. Therefore, I was not aware.
You are not disengaged the chartered accountant initially engaged. They were still supporting you as your chartered accountant.
Yes, yes.
So then, if the notice has been sent to the properly chartered accountant, how does it matter? And in any case, you had entered appearance on 18/7 before them, not 18/7, 22/6.
22/6.
22/6, and you had yourself sought for a last opportunity, which was acceded to. You were granted 20th of July.
But I was not aware of that 20 days being given to me. I was not told about that particular date. Because what happened is, I had given my new email ID. Therefore,
You knew very well what had all transpired in the previous dates.
yes,
That is when finally you entered appearance on 22nd of June.
true, man.
22nd of June, you entered and then you requested for a one last opportunity for personal hearing,
Yes.
which was acceded to.
Anything there from this?
It was incumbent upon you to ensure the follow-up thereafter. Why do you even thereafter adopted the same method of your style of functioning what you were having in the previous years?
Because these dark clouds stare at me. The only silver lining I'm saying, my lord.
Only because you made an effort by a change of an email ID subsequently and notice still being sent. But the services of that chartered accountant continued.
But my lord, this was only a person for secretary.
That is difficult
My lord,
to say.
I have the
We cannot accept these grounds and call it to be a violation of principles of natural justice.
My lord, I have certain.
How more could the department have accommodated you?
My lord, my only difficulty was.
You cannot call them to be arbitrary or malafide, so neither can you hold the decision to have been taken in an hasty manner.
Well, I'm certainly not alleging arbitrariness or malafide in this regard. Certainly, there are shortcomings on my part. But
Only on your part.
But having changed the email ID at least, having made.
But that is much after you were well aware of what all transpired in the previous years.
The difficulty, my lord, was I did not know the exact date also, my lord, which was given to
You were required to. You were required when you had entered appearance there, and you were required to follow it immediately thereon, so that no further damage causes.
Because today I am in a predicament because of my consultant not forwarding me those emails. Because
That is an excuse being taken by every SSC before the High Court for filing of it, because the chartered accountant did not respond, because the other local council did not respond.
I cannot better those facts, my lord. But the reality is, I have an affidavit also, my lord, from this consultant.
Obviously, yes. Why would he not give an affidavit? You would ask him.
Because
He'll provide you 5, not 1. That is
because
the
it will be mistake. My lord, may I make another submission? At least when an order is being passed, to me, my lord, an order is being passed against me, where there is a no reply or no personal hearing. At least, my lord, the material on record should be considered. My lord, may kindly permit me to explain, my lord. I am in a transaction where I am a landowner who is receiving certain built-up area under a joint development agreement. Plus, from my share, I am making sales of units to third-party customers. The department alleges, my lord, said,
What prevents you from filing an appeal? Go file an appeal.
well, at least the material on record should have been considered.
That would also be a ground available to you in the appeal.
My lord, the very basic condition precedent, my lord, was to consider whether the jurisdiction is made out. May I please show the impute order, my lord, how they deal with it? Kindly just see, my lord, say page 80.
See, even if it is beyond.
I will may kindly see at page 82, my lord. My statements were there where my simple submissions were made as to whether there is any liability or not. They don't consider that also, my lord. Kindly see at page 82.
Is good ground for your appeal.
Well, but it has to at least consider what is the material on record. I at least there a requirement that they have to comply with.
Go file an appeal.
My lord, may I, at least, my lord, may I show what I had argued, my lord, before the law authority.
You did not argue at all.
My lord, may I make one request?
Yes.
I have also challenged, my lord, the valuation mechanism and the very jurisdiction to pass.
The appellate authority decide all these and then come.
But my lord, may I show one judgment, my lord, of our own High Court?
Yes.
Of our own High Court. Kindly see at page 316, my lord. Those may permit me to read. So this is repetition 8650 of 2018. After having failed to avail the opportunity given to them to respond to the show cause notice, the dealer has come up with the above repetition challenging an order of possession passed under the AP Act. But so-and-so learned counsel for petition and so-and-so learned special planning counsel for respondent. The person who fails to avail the opportunity to respond to the show cause notice cannot make a complaint of the violation of natural justice. Therefore, objections based upon violation of natural justice are liable to be rejected outright. But the learned counsel for the petitioner submitted that at the time of audit, the petitioner produced certain materials, and that at least those materials ought to have been taken into account before the impugn order was passed. If the dealer has actually produced any materials at the time of audit, the same deserves to be taken into account even if the dealer fails to respond to the show cause. Petitioner has produced a copy of unaudited letter containing details of Form 501B and Form 550, allegedly submitted at the time of audit. This letter contains the rubber stamp of the Office of the Assessing Officer. If so-and-so learned Special Standing Counsel submitted that these forms are not available in the assessment file. If there is prima facie evidence to show that Form 501B and Form 550 were furnished at the time of audit, we are of the view that the failure of the assessing officer to take into account the same before arriving at the taxable turnover and the tax payable on the basis of best of judgment may not be right. Hence, we are of the view that one opportunity should be given to the petition. Therefore, the writ petition is allowed setting aside the interim order. Remember certain timelines. Because what I'm saying is at least the material on record where I've made a submission and my statements were there where my submission is recorded. That at least has to be considered. If I may just show my lord from my statement what I have said. This is at page 167. This is where my statement begins. Because what happens, my lords, even appellate authority doesn't have the power of remand of my lords under the GST. My lords, may permit me to show at page 168.
One
168. This is a part of my statement, the managing director statement. Because we kindly see the third last paragraph in the middle of the page. Your attention is drawn to.
Yes.
Your attention is drawn to Schedule 25B of CTST Act, which says construction of a complex building, civil structure, or part thereof, including a complex or building intended for sale to a buyer, wholly or partly, except where the entire consideration has been received after issuance of completion certificate where required by the competent authority, or after its first occupation, whichever is earlier, the supply of service. Why have you not paid GST and service tax under Finance Act 1994? Section 66C declares it. I state that sale of units falling to our share is neither transaction in goods nor services, but is in the nature of sale of immovable property, which is not subject to GST or service tax. We, being the landowner, neither engaged in construction nor required to obtain completion certificate, thereby not required to pay GST or service tax in this end. Further, it is clear from Circular 151/2012 ST that liability to pay ST on the plan.
This again is factual, which will be considered by the appellate authority, if at all, if the authority has not decided.
But my
Why
lord,
should the writ court consider this at this juncture?
my lord, what I am saying is the impugned order notes this submission at page 82.
Yes.
My lord, we kindly see at paragraph 12. How they see this question. Paragraph 12. From the statements given, my lord,
Yes.
the statements given by Shri Girish Malpani, MD of CPM Hotels, I find that they have received the occupancy certificate from the competent authority on 19/5/2020, which is later than receipt of consideration towards sale of built-up area of the project under the name Vasavi NPM Bank. They have not discharged GST liability on the same. He deposed that the consideration is received during the period from July 17 to March 21 for sale of landowner share in the said project. And there is no sale of built-up area in respect of other two projects. He accepted to have not discharged the GST liability with an intention that sale of units in the project is in the nature of immovable property which is not subjected to GST as per Circular 151/2012, service tax dated 10/2000. Now, how he deals with it? In view of the above and statements of Shri Girish Malpani, MD of NPM, I find that NPM BPL have received consideration of so and so towards sale of built-up area of the project. Under Vasavi NPM
That is what we said. This again is, even if it is a wrong appreciation. That
There
is
is
not
no
wrong.
appreciation. In fact, he at least they tell you the key point. Because he simply says that the sale of built-up, in fact, sale of built-up area is clearly outside GST. At least he could deal with this submission. He himself says, my lord, that matter 9 that I have considered the show cause, I have considered the relying upon documents, material, and records. So that's why I'm relying on that decision of our Honorable High Court, because at least whatever submissions were there.
That would also be considered by the appellate authority. They
But my lord, the appellate authority, my lord, also doesn't have the power of demand.
do not have it, but it can set aside the same.
Even if he sets aside, my lord, then this issue would, my lord, ultimately all these questions have to be gone into. My lord, can also think from one other perspective. If sale of land is totally outside the purview of GST, Do they have the jurisdiction, my lords? At least the jurisdictional fact should have been considered.
Can this not be considered by the appellate authority?
My lords, but the extraordinary jurisdiction has been invoked, my lord. The jurisdictional question, if I am subjected to the entire rigmarole of the proceedings without the
If you-
jurisdictional fact being considered.
Deliberately do not appear before the assessing authority in spite of repeated opportunities being, in spite of you yourself having entered appearance before the authorities and sought for one last opportunity. And even then, thereafter for a considerable piece of
That
time.
last
And
opportunity
then-
I was not told, my lords. I didn't have the date. I put in bona fide my
Why
hearing.
did you wait for a notice? When you went there and you sought for a last opportunity, it was all the more required on your part to have further process, followed it up.
Because I followed up by having my email ID changed. At least they say that they have informed me by email.
Further created complications.
Because the latest, as the email ID is uploaded on the board,
Yes.
it is then, my lords, I should have been informed. My lords, I actually consider, my lords, not,
Difficult.
my lords, this is not a case of, my lords, I have prepared my reply. I could not file it in time, my lords, certainly. So, my lords, ultimately, my lords, the petitioner is being faulted, my lords, for conduct of a consultant, my lords, which he is not in control of. That also our High Court has considered earlier, my lords, therefore, negligence of a consultant.
The challenge in the present petition is to the order in reasonable grounds by
So can we say all questions of law to be kept to?
the questions of law raised by the appellate petitioner in the present case. However, is ordered and is left open to be considered by the authorities concerned in an appropriate proceedings. Yes.
That's here for right to a court.
So also corresponding to she
Okay, that's the floor.
Lordship, we pray for some time, Lordship. Kindly have this matter in the next week, my Lordship. Serial number 28, Lordship.
28.
Yes, Lordship.
There is no interim in your favor.
Lordship,
Is there any interim in your favor?
I think so, Lordship. Actually, I don't know about the case. As senior is unwell due to cold.
At the request of the council for the petitioner, list this case on the 3rd of January.
Okay.
Yes.
Thank you, sir. Good, matter come up for application. Interest was disallowed on the investments which were made by the SEC. But I've gone through the entire orders on this part, but the finding is that the investments that were made in the shares not come out of the own funds of the SEC. And therefore not interest could not be disallowed, but it's finding of fact problem which I do not find anything to explain. But page 6, not page 6. And 4.
Just 1 second.
Yes.
Yes, please.
But page 6, not paragraph 4.
Yes.
Read by the order of the OAC before the next you could see the deleted resolutions with the following case. Yes, its own case, 98 number 763. This IPA note which they follow, but against which we filed an appeal, your options were blocking options noting that it was dismissed. But the reason not that fresh separate copy was not filed. So the copy that was filed before on the
Default, yes.
underlying. The earlier order, we have considered the language of the book, taking the material available in the court. It's not too beyond any doubt that the investment space that has been created in the its own sources and the nexus between the investment and the interest statements available in the SEC from the annual reports by the SEC. The generation of profit by the SEC company and internal fees. Therefore, things on zero trades, etc. are well enough to cover the investments. The only ground on which this loan was made by the loan is talking in question. But the SEC had not made the investment in question in saving this period. Had he not made this investment, the SEC will not have borrowed money from banks. The question that has been considered by the economic stimulus payments in the economy. But whether such investments are made up of loan funds or of borrowed funds, and there is such investment in the company. The state cannot decide on account of commercial activity efficiency of the business of it. Moreover, the power cost line of business is very huge. Full collective contribution of the key. But the investment has been made on account of commercial efficiency, as it was to improve the profitability for the company by obtaining power floor rates for the FC company's operations. And as such, the FC deserves the benefit of government discipline in case of escaping. In this view of the matter, though the authority now considered that people were not interested in making interim decisions. Therefore, typically we not best based on the tribunal in the case. In the case of CIT Reliance Utilities, Bombay High Court, the duty to this treatment and utilize the investments in borrowed funds utilized for business purpose. The fee is eligible to claim deduction in the sense of interest paid under the policy of the Act. Even though the issues to follow the application. The Bombay High Court which was considered a treatment really applies to the cancer of the but in fact, Bombay High Court patient the Supreme Court has dismissed this. Therefore,
What is
I
there?
cannot really assume
This is exactly what
finding of yes.
the instant is an appeal.
You so.
NATCO for fun. Is it fun or pharma?
But it's not for the mistake.
NATCO Unlimited versus income tax. IT and Bombay High Court, the citation is there.
Bombay High Court is 313 IPR 340.
No, Bombay High Court, it is in the case of not CIT versus Reliance Utilities.
Yes, CIT versus Reliance Utilities and Power Limited.
Decision of the Bombay High Court in the case of CIT versus Reliance Utilities and Power Limited. What is the citation?
Citation is 2009 313 IPR 340 Bombay.
340.
Kerala High Court, but the SP officer relied on Kerala. Private discrimination.
Eighty, 30, you are there? Item 30.
The Lordship, I am for the petition. PB service.
Yes, what do you say?
The Lordship, this is a case of death, my lord. The claimed amount is 30 lakhs. Awarded amount is nil, my lord.
Awarded amount is?
Nil, my lord. They have not awarded any amount. Saying that there is a fault, the negligence is on part of the deceased, my lord. The Lordship may kindly see internal page 7, my lord.
Anybody represents the respondents in this case? N. Jayasuriya. Is he for the insurance company? He appears for first respondent, the claimant. Who's there for L&T insurance?
And these best HDFC.
You're there for HDFC. So you are there for. Satish, you will have to give a copy of the memo of appeal to the
We will serve a copy.
non-prisoner.
We will serve a copy, madam. Kindly post after 1 week, we will serve a copy.
The non-prisoner will be present in the court and for the.
Connected to ITDA 252 19 milligrams. That matter is posted on 16 11.
Admitted or not?
This is what I am informed by the website.
I beg to represent respondent, my lord. I beg to represent the council, man. That appeal is still not admitted, my lord. Both these matters arise from a common order that is pending admission on 16th November.
16th.
1/6. Yes.
The appeal will be listed for hearing on the 16th of November along with ITTA
252 of 2019.
252 of 2019.
Okay.
Thereafter, sir, we, your
That's not a case of death. Amount claimed is like 1 crore 11 lakhs.
Anybody for the claimants? Claimants.
The amount claimed is 1 crore 11 lakhs 20,000. The amount granted is like 98 lakhs 10,262, with interest at the rate of 9%. The insurance company charged me 3 grounds. This was an employee traveling in the company's car. There's no separate premium has been paid as required in section 29 of the IMT Act. The first one, second is only a private employment. It's instead of 25%. 30% was taken for the future prospects. The interest is at the rate of 9% was granted instead of 7.5. We have 3 grounds. Basically,
Second and third stands rejected. You address on the first one.
but it's the yes, because yesterday they should have the interest rate is very less.
Usually there we are not interested.
Now, when Sarama says that it's only 6%. As for the first round, is that
The latest judgment is 12.
yes,
There is still a potential chance of enactment.
we have to rely on the.
That's why I said we are not interfering.
This ground number 5 is taken. It's identity 29. In fact, this ground we have not taken the 4 below. So where are my important?
So everything goes.
This is what it's because it's an employee because traveling in a car. It's the No.2 is a policy issue with a comprehensive policy. But the subject as per the IMT 29, this is the 29 part says it's I have extracted 29 at page number 3 of my ground structures.
But if you have not agitated it below the before the court,
Yes, that's that plea was not taken.
no evidence also led in the
Yes,
system.
that's in, we are not abused in evidence. It's only a legal issue.
The present is an appeal. In the
These cases, the rest of the things is almost same. 1 crore 42 lakhs 40 crores is claimed. 1 crore 23 lakhs 66,000
Everything is same. Everything is
because both of them are going in the same chief.
The disease in this case is the another traveler.
Both of them are going company.
He also was of the same company.
Same company, both of them same chief.
The disease in this case is Avinash Vardhan. The claimants are the
Wife, children, mother and father.
Questions of law are formulated in this appeal also. But one is whether the expenditure on employee stock option plans are to be declared revenue or capital expenditure. And secondly, whether the notional hedging loss is to be treated as expenditure because it's only notional in nature. The same question, Your Lordship, when with regard to ESOPs, with respect to the same SSC came up in ITPA 12 of 2022 and admitted on 13/6/2023. And as to hedging loss, is ITPA 108 of 21.
108.
2021. 8 of admission I'm not having with respect to the hedging loss question.
The appeal is admitted for hearing on the following substantial question. Respondents when issuance of notice can disclaimed with, let the appeal be listed for hearing in its usual course along with ITTA 12 of 2022 and ITTA 108.
21 as well as
108 of 2021 as well as
85 of 22, which is at item 37.
85 is listed today. It's already admitted.
It's already at 85. This order was thought to be recalled up 2 years by the tribunal, and they passed fresh orders raising additional issues. So that has been challenged, and whether the tribunal has exceeded its power in 254 has already been framed as a question in 85.
In 85.
In 85.
37, it since it's already an admitted appeal, this case along with the present law. Yes. What about 38?
Yes, adoption for
Oh, these two have gone. People 36 have already been.
35 and 36 went along with the batch in the morning.
Yes, yes.
34 and 37 are now covered by the budget.
Yes. Yes, Mr. Radhakrishnan. What do we do next week?
Next week.
The request of Sri A. Ramakrishna Reddy, the instruction sheet. Taken up on?
Regarding the refund method, which was unlawfully withheld by the officers.
Challenging that they prefer an appeal. That has been.
Are we to hear today or?
Can we dispose of the road? People's lordship. The issue was.
Challenge by the only demand notice because it's pending before the tribunal. They have not obtained any stay order, no, they have issued demand notice. That challenging that they have all this repetition. Whatever the claim by ownership, unless that has been decided, there are.
So if you are prepared, we can hear it today itself.
Yes, it's not. Because Anika is, I mean.
You don't have the bundle.
Lordship, kindly say, page 14 the note, 14, 41, that itself is evidence.
He doesn't have a bundle. You will have to help him.
It's same about it, I remember it.
Only the challenge demand notice, unless that has been decided.
What is?
The challenge.
If you are ready, let him argue. When do we take up?
Lordship, one small submission. This is in fact a case where the petitioner is eligible rightly for an amount of 44 lakhs and in excess of 12 lakhs as per judgment order itself. Even in the counter mirror, they were never denied. And they are refused. They are saying that right now that we have filed an appeal. The appeal was in fact filed on merits, which despite after considering the entire amount, the petitioner is eligible for an excess of 33 lakhs. This writ petition is filed challenging the refund claim, challenging the notice and also claim for a refund. That's the grievance mirror. On the one hand, they are.
And we have it next Monday. Right. Then you will say it's election time.
Everything will be on.
It's almost 20.
Everything would be offered. Coffers also would be open.
Unless that has been decided on tribunal. With the assessment order. That has been challenged before.
That is never challenged.
Correct. The question is, do we hear it today?
Or
This is never on the assessment
Since
order.
2021.
Yes, madam. And that way it is a refund claim, madam. We have been rightfully.
Unless that has been decided, the assessing authority cannot proceed with this.
One small submission, madam. Lordship may kindly see the representations of petitions made.
We'll have it on 29th. Why? What is difficulty? Next week there is some difficulty. 29th and 1st, what difference is it going to be in just 2 days? Out of? Both of December. Both of December. No further adjournment. Fifth of December. The request of the Ghana State Council is this case on the 5th of December with an understanding there shall be no further adjournment.
But in this matter, not a reply has been filed along with certain petition. But it's what the application of the file. We are introducing the petition and the 3 or 4 weeks.
4 weeks.
For a period I'm not here.
The whole batch is going over. He is also not there. When do we have it?
The 12th, it's a very late.
After 12th of December. 18th. 18th suits you. At the request of the council for the department release this case on the 18th of December. You have some interim in your favor? You have some interim in your favor?
Yes, sir.
The interim will continue.
But we are content with the request to look and
Counter not yet filed. Any short date is January. The earliest is January.
The issue is fairly settled. It's only an issue of refund.
Then they will drag it up till May 24th.
That's why clear also.
The government is dragging it till December. The central will just drag it till 24th May. Fourth of January, at the request of the council for the department, enabling them to file counter.
Well, would your lordship kindly grant a passover in item number 42? Senior is appearing in this matter. We're ready for your here.
It's not time for filing a reply. So I thought they would be filing a reply. If they want
Only a legal issue is involved. If either could passover or any other date, Malaj, we'll commence. We'll argue the matter.
Because the department says that on the last date of hearing, you have taken time to file some reply.
Yes, Malaj, I believe the reply has not been filed, but the issue may not require a reply, Malaj.
We'll take that statement of yours and we'll fix it for hearing.
A pleasure.
Today, the learned counsel for the petitioner submit that there would not be any necessary for any further reply to the matter itself can be decided and the matter be
4. 1 to 4.
I'm representing Swarup.
Appearing,
Sorry for it.
yeah,
Respondent. The hardships are dealt with the same issue in account for 27. In item number 27, the issue was very weak, which is covered in function.
But I thought that he is asking some adjournment.
yes, yes,
So he comments not me that.
yes.
That the state report, that is the repetitioner. That the impute order, that in Virginia stated 29/10/2020, one lot is challenged before your lordship, mainly on 3 grounds. My first submission before your lordship is that the service tax is not levied from 2014-15 to 17-18. So 14 it is the combined state who is having jurisdiction, but not the third respondent, not the state of Telangana having jurisdiction. So therefore, that part of the order is without jurisdiction.
How?
That your lordship kindly see that page number. The prior to bifurcation, 26/2014 is the bifurcation. From April 2014 onwards, he has taken the period. In the impute order, lordship kindly see that the first component is the page 49, your lordship kindly. 14/15. Page 49. One 2014 to October 2014. This period is covered at that relevant point of time. The state of Andhra Pradesh, that is the principal secretary, the commissioner, principal commissioner, Vizag is having jurisdiction, not the principal commissioner at Hyderabad. That is that first point. The second point, not your lordship kindly see, that the service tax is not levied on 3 components. Lordship kindly see page 49. The details of the rentals and lease amounts released by the work board and work institutions. That during the period April 2014 to June 2017 are arrived on basis of the receipt on payments of statements and in the absence of month-wise income details and the rental income of the entire financial year 17-18 is assumed to be realized during the period 2017 to June 2017 itself. Then further each of the financial year, the highest service tax of so and so so and so. Let the first part you lordship kindly see. Let work fund and work institutions. Lordship got it. Let the lease amount received. That in the tabular column, 6.4 para I am reading that. I have read the 6.4. That tabular column that is let work institutions fund. The next page, not page here.
This is an appealable order.
So that's true,
Why not an appeal?
that the particular period is not without jurisdiction.
That is the only ground
That is one ground.
which led to you filing the writ petition.
That is one ground. The second ground is not your lordship kindly see. Not so far as the land acquired by the government. The workload land has been acquired by the government. Compensation has been paid to me. I received the compensation. Board received the compensation. There is no service rendered to any board. In spite of it, on that also tax is levied, the second aspect. The third one,
That again is a ground which would be available to you in appeal.
It is also covered. First ground, lordship kindly see. The period 2014 to 17, 18, that period is covered beyond 5 years. Beyond 5 years. Not by limitation.
How?
No, your lordship kindly see 14 to 15.
Yes.
This is April that they have taken. April 2014, 5 years.
Yes.
That by end of April 17, show cause notice you not kindly see. Let's say show cause notice date is dated 22nd, 23 9 26.
23/9/2020.
That date is 22/9, but this is not the dispatch.
So far notice is dated 23/9.
Yes, 23/9.
Yes.
Page 72, 73, you want to get that. Page 73. The page 79 is the relevant flood in the show cause notice. Non-payment of service tax on the rental income that the third respondent has taken that again not page 80 not NDC of institutions that work fund that these two blood is received by the respective institutions. Blood below blood every year blood what institutions have received this income so far as the rental income is concerned. Blood they have levied blood service tax on the board. That is one aspect. Then blood the limitation to Rochester kindly see calculate from April 2002 to blood June 18. Blood 2014 to 15, blood page 80, you Rochester kindly see. 14, 15, then blood 17, 18. Then you Rochester kindly see section 73. This is beyond blood 5 years. These are all the figures taken blood from the website of blood board of institutions. And blood they limit the blood service tax. Blood 73 your lordship knows Blood. And the 73 one however says blood 5 years. Blood. Provided blood you not ITC, where any service tax has not been levied or paid as being the short levied or short paid or erroneously refunded. Blood. Reason of fraud, pollution, willful misstatement, suppression of facts, and blood. Confirmation of any of the provisions of this chapter or of the rules made there in that zone. 5 years only.
5 years from which date?
From the date of that first blood commencing April.
Read that provision 5 years from?
From the date of Toka's notice. Toka's notice is blood 23 September 2020.
Yes. Yes. No,
EPC.
Blood from Toka, date of Toka's notice 30 months blood.
One submission, Your Worship. Your Worship, I kindly have it tomorrow, Your Worship. The copies also have been served on us, few minutes back.
Why did you permit him to argue for 20 minutes then? You entered appearance, you raised a preliminary objection. Now, after arguing for 20 minutes, now you want an adjournment, saying that you have been given the bundle only today. Would you not have stated that before? Very strange. You should have said that in the beginning itself. Tomorrow. The request of the council for the department is discussed.
Okay.
Who's for the appellant? Did you find him today? You are representing the insurance company. You will help us in deciding the appeal in favor of the appellant. In his absence, there should be somebody to help. We'll go together. What is there? The dog I know for calculation is all settled. His claim has been dismissed. You don't have the bundle letter. The claim petition was dismissed. None appears for the appellant. Raised this case on the 5th of December. Just give us your name so that it can be reflected in the cause list.
My name is Mukund Reddy, person I am dependent in estate. In estate is legal.
You are appearing for?
Estate is legal.
It's already there.
There. Hearing the counsel for the petitioner, I know that is one.
Yes.
Will have it after 2 weeks.
For what?
Just convenience here.
To argue before this bench. This one's entering appearance for the counsel for the appeal raised for time. Has prayed for time. Want to raise this case on. What is this?
Earlier, last week, there was no time, next time. This is the case where the petitioner is challenged the restraining order. The case was okay. There is no dispute of the money. But petitioner also compared to well, of which he is paid only 20%. So keep it like number. That is the case on page 17. It is my counter.
Did he pay the 20% of the outstanding areas? That has also not been paid.
Even on the date of filing, the counselor has verified with the department is complete. Is not.
Not used. You are appealing for both 1 and 2.
1 and 2.
Password. Have you taken any steps thereafter for recovery?
No, there's stay.
There is no stay.
Stay because of 20%. There will be.
Subject. Subject to. If there is non-compliance, there is no stay. Then there's other rider. If the interim or if the amount is not paid, the interim stay will no longer be available. So it's not there. You can, you are free to do that. That would have brought them to the court. Today they are under the impression that they have that interim protection. The stay in any case is not there. Anyway, just pass over. 230.
Have you seen for the study of
Krishna.
Taking the computer and this with the final 826 good.
Hearing?
Yes.
When?
860.
November, December goes now. Only in January will be. They have an interim order in their favor. Not November, December, only in January. 2023 matter. 23rd January. Since the pleadings are complete, the counsel for the parties say that the matter be listed for hearing some other day. As grateful as this case on the 23rd of January.
My lords, apologies, my lords. I'm sorry, my lords. I appear for the petitioner in 52, my lords. I think my lords have dictated the order.
23rd of January.
Well, it was a short issue, my lords. The pleadings are complete, but I leave it to my lords, my lords.
Councils were not ready, perhaps. They wanted that it should be listed for final hearing, then to hear it.
Very well, my lords. Because, my lords, it's a question of, my lords, I had filed a few returns, my lords. The acknowledgement is on record, my lords. They've come back in the counter and said that ultimately you've still not filed, my lords. That's the short matter, my lords. My total demand was 15,000 rupees. A penalty of 20 lakhs has been imposed, my lords. This is a question of profession tax, my lords. I just have 4 employees, my lords, in my company. My total liability to pay professional tax in the year is 15,000. My returns are on record. The officer says that please, you've not filed the return. I give him 4 letters saying it has been filed.
You have an interim protection in your favor.
Please, my lords. My lords, I was just pointing out. My lords may have it whenever it's convenient.
We'll have it on 23rd of January.
Very well, my lords. Obliged, my lords.
Let's get some problem. You proceed, sir.
What is the issue?
Kumar is a very fast senior counsel. He also have to fight counter.
In 55, 57, and 58, I'm appearing for official components to file counter.
All these petitions are connected in
Other cases, and internet.
One and the same issue?
Yes, yes, no,
One and the same issue raised in all.
yes.
Consumer complete the construction and pay cost method on which they have come into.
We find
He says he filed an insolvency petition. It's not yet decided. He only filed it. So he says this has to be straight. The EP has to be straight, execute.
But there is no stake.
No, State Commission gave a very detailed order.
They are also not pressing for the stake. So you can press the EP there. They are not pressing the stay here, you can press the EP there. The 3-2.
67.
67. When do you want it? Goes in January.
Yes.
No hurry. By that time it will be executed. No.
That's how he files petitions and he wants the matter straight.
No, we
Now
are.
he says it's in the high court. It has to be heard.
No, we will make it clear. When it counsel for the petition of praise for time, as prayed for time granted with this case on 20
Millards, on the last occasion, your lordships had asked the department to get instructions because I had made a statement in my writ affidavit stating that the order was served on me. The impugned order was served only on 3/10/2023, whereas the date of the order is 26/3/2019. Your lordship had asked the department to get instructions with regard to this service and with regard to this statement, Millards.
They have got specific instructions. It was duly served upon you long back in 2019 itself.
Let's kindly have it tomorrow. Let me also just have a look at that paper, and your lordship can. I have not gotten the opportunity of looking at the.
What is this?
Millards, insofar as uploading is concerned, Millards, if your lordship sees Rule 64 of the Telangana VAT rules, a mode of service of notices and orders is prescribed, Millards.
When was this uploaded? 31/3/2019.
The first membership was also RPD membership that was written as not claimed. The assessment order was served on them. One is their present address. One is that fiscal matter.
The registered notice was not claimed.
Yes, sir. Local notice.
Millards, may I show only one page of the writ petition, Millards? Millards, let me just point out one aspect in the impugned order, Millards.
Unless you cross the delay
Yes,
part.
Millards, insofar as the delay is concerned, Millards may kindly take Rule 64 of the Telangana VAT rules, Millards, in
Yes.
which Millards, Rule 64, mode of service of orders and notices.
Yes.
Millards, may I read it out? Unless otherwise provided in the Act or these rules, a notice or document required or authorized under the Act or these rules to be served shall be considered as sufficiently served on a person being an individual other than in a representative capacity if it is personally served on that person, or it is left at that person's usual or last known place of address, or it is sent by registered post to such place of residence, office, or business to the person's usual or last known address in the state. Millards, there is no uploading is not prescribed under Rule 64 of the Telangana VAT rules. Millards, in fact, previously also a division bench of our Honorable High Court also has taken the view that under the Telangana VAT rules, email service or uploading does not amount to service of the order, Millards, and there has been no amendment in Rule 64 of the Telangana VAT rules.
Thank you, RPD membership was written.
Even the registered notice sent has come back unclaimed.
Millards, may kindly see the endorsement with which it has come, because Millards merely it can't be stated that it's unclaimed. Millards, there are several points to endorse whether Millards, I have not only if it is refused, Millards, it is a deemed service. Millards, if I have refused the notice, Millards, your lordship can count it as deemed service.
Not a few was no one is declaring that address. Present to that they have not furnished alternative address as a student.
Well, it's just one page. Let me show your lordships. The basis on which the order is finalized. Well, it's because right now it has been stated that I have never received any notice. Well, it's whether unclaimed is treated as service or not, your lordship may put it aside. But I have never submitted a reply. The dealer states I have filed a reply, and on one hand, he states that the show cause notice has not been served on me. On the other hand, the officer states that I have filed a reply accepting the additions, Malats. Well, it's in the same assessment order, Malats. Well, if your lordship just looks at Malats page 19, as if your lord. That's on page 19, last paragraph. The officer himself states, I have not filed any response. I have not submitted any information. Well, it's on page 20, if your lordship comes, again, the same officer in the very next line states that I have submitted a reply accepting that these are the turnovers, Millets. On one hand, the officer states that no reply has been filed. On page 19 at the bottom, if your lordship sees the last paragraph on page 19, it is the neat copy of the impugned order, Millets. As accordingly, a show cause notice dated so and so has been issued by reference cited proposing to levy higher rate of tax on taxable turnover in absence of details. The same was served on the dealers and subsequently issued notices by reference third and fourth cited and several personal hearing calls, but there is no filed fully information to conclude assessment. Even after giving ample opportunity and time to submit the full information, the dealer neither submitted any objections nor adduced any sufficient cost, preventing him from producing the remaining statutory forms. Hence, the assessment is proposed to be completed on the available material filed by the dealer. Let's come to the next page. Further, the dealer in his reply stated that they have done intersales turnover of rupees so and so and branch transfers of so and exports of so and so during the year 14-15. Well, in fact, even right now, the department had submitted that the notice had returned as unclaimed mallards. I have not received any show cause notice. He confirms the turnover tax on the basis of a reply which I have never submitted.
Which is this, a subsequent address that has been shown? What is it? Karam Road, Amirpet, some apartments, Sridevi.
The proprietor. Assessment order was fiscal matter. No one is there in the state assessment. And was the assessment order not trying to like when so such person is that
Page number 20. Page number 20.
from page 14 to 21, the documents were not understood.
14 to 21 page number is not served to you.
I think they gave everybody information. It's not sir. From 21 is there. 23 page 23 it is there. What they started.
Well, on the last occasion, the standing council has stated that he didn't receive from Annexure P3, so I had given him at the time of filing, so I had given him that copy again. Well, it's on the last occasion when the matter was listed, the standing council had stated that he did not receive Annexure P3, so I've served P3 again on him, Malaj. Now he comes back and says P1, P2 also are not there.
You don't have the final assessment order anywhere?
At last page 81 is there.
What is that?
Same order, Malaj, certified copy.
Here it is there. But it's 21.
Now come to page 83. The first line. Dealer in their reply. If you say that he have not appeared at all along in spite of service, when did he file his reply? And which is that reply that you have relied upon?
In the reference also a letter, on page 81, if your lordship sees in the reference also the letter is mentioned, but
read the previous page, page 82, the bottom paragraph. There is some contradiction there. What do we do?
Yeah, and let them give an opportunity. Okay.
When? When we set aside this and remand it back? Which date you would appear? Give us a date on which you can appear.
Well, it's 2 weeks, Malaj. After 2 weeks, any date your lordship may fix, I will go submit all the documents, Malaj.
4th of December?
Obliged, Malaj.
Present is a petition assailing the
Obliged, my lords.
On the last occasion, when allowed the subscription petition directed to the notice to be published in the newspaper. I sent an email to the company along with the draft notice. I did not get any response from them. But gives one more opportunity, I will send an email to them if they don't respond. In fact, the notices which were sent to the address of the respondent is want to be returned with the endorsement that no such person in this house. That it is in service according to the judgments of the Supreme Court.
That stands. No, there may be judgments to that effect.
Once
But that is now of no consequence for the reason that on the previous date of hearing, at your request, we had permitted substitute service.
Last before the earlier bench, I made the same request, but the bench said that let there be a notice of publication. That is why I filed the petition, and your lordship allowed it on the last occasion.
Now that we have allowed it, that stage goes.
That stage goes.
Now the difficulty
of the court, both the stages.
No, the difficulty is the appellant himself is not interested to proceed.
Sent an email along with the draft notice.
So that means they are not interested.
I don't know, sometimes they may by mistake
Please
the
order.
email. If one more opportunity is given, I will send one more email. Otherwise, I will leave it. Because sometimes they miss the email. I checked my mailbox and there is an email. In pursuit of the order of the Supreme Court, I filed the SS petition. That was all. Therefore, in spite of the fact that the notices, though
the appellant must have now found that this amount is too meager an amount to contest. Therefore,
it is not like that. The company is not doing well. The staff is less and the work is more. Sometimes they may miss the image.
The work is more, staff is less, means that the company is doing well. Company is doing well.
Not doing well at that time. Because I am yet to get fees in about.
That's a usual complaint for all the councils.
Since I did not get the fees, I believe that they are not doing well.
No, it is they are trying to avoid that also.
Still, I am trying to defend them. I am asking for one more opportunity.
Counsel for the petitioner, appellant please for one more opportunity for compliance of the order dated 25/9/2023. As paid for time granted is this case on the no, we will pass a preemptory order. If you fail to take steps within a period of 4 months, the appeal stands.
Yes,
Closed.
that will be fine.
What is that?
They have accepted. They did not file any appeal.
By making necessary publication in the daily paper.
Next is my madam, insurance claim. My request today, my difficulty will not make any past placed. Posted.
We will give you our file. We will share one.
After tomorrow, next week, next Wednesday.
What about second half? Today second half.
There is some.
You should not take. We are providing you with your experience. It should not take more than half an hour.
Day after tomorrow, my place, I wouldn't not read. Otherwise, next week after the following answer,
You are for the respondent. Excellent.
I'm the respondent 1 and 2. I'm the claimant.
Tomorrow, day after. Where? Day after.
Next week Wednesday. Next week same Wednesday.
Monday. Tuesday.
March.
And the reply to the council for the petition is on 15th. 15th of
March.
The 71 is filed by the claimants for enhancement. 72 is filed by the respondents for instance of the challenging the one.
The income of the deceased is taken and I told you some of rupees 10,000 per month. They 16 your lordship and this is 11.
The date of accident is
The date of accident is
28, 2014.
Okay, yes, sir. As on the date his age was 32 years.
Age is
32 years.
32 years.
Yes, multiply is
Working as
is he used to go to abroad, that is Qatar. And he used to earn by the 1,500 Qatar riyals. Is equivalent to the Indian rupees is 25,000. 50,000. And he also used to earn by doing overtime work.
you are for the insurance company.
No, enhancement payments is from
72 is my lodge.
Your you are challenging the quantum.
Yes, Lord. The quantum as well as liability.
What is your contention so far as liability is concerned?
Your Lordship, RW1 is a conductor. He is examined, stated that this is to on the board of and starting on the mobile phone. He did not observe the first para number 16.
Para number 13.
Yes. Para number 12. No, sir.
What is there to disbelieve PW2, the eyewitness?
The conductor also I test.
Conductor was not an eyewitness. So PW3 is the eyewitness. There is nothing strong available to disbelieve the eyewitness. What is the challenge to the quantum?
He worked as a carpenter for a period of 3 years or 1.5 years. And he came to India in 13 days. He is not working. Page number 12, also paragraph number 7. Also not produced any document for the requirement.
No, that is PW4.
Yes, sir.
What is A7 and A9?
And then is the original passport of the deceased man. Seems a renewed one. Ring is also passport.
Which is the one renewed?
But A9 is
A9 is the renewed one. Renewed when?
And both are expired.
Is on the date of maritime, then it was not any correct, that passport is expired. What for signing of the report below.
Para 16.
Yes, yes.
Both these passports are renewed, got expired. So that means he was not inclined to move out. There was no proper passport.
But he worked in Qatar.
Must have done something there.
Yes.
But that cannot be taken into consideration.
Not only that, but consider.
He has been there only for 13 days. That is the only period he has worked there.
But here to that also you need to go regularly to the Qatar.
What used to go means
He is a carpenter and is also having a driving license, LLB, tractor and trailer. And they have changed.
welder also.
My lords.
Oxygen welder you said somewhere.
No, it's not that.
I mean, that's your claim. That's the claim of the claimant.
We know your aspect and say exhibits 9 to 24 Marat 5 shows that Marat is also having a agricultural land standing in the name of Marat the appellant before your lordship, his family members. He used to Marat
It remains with the family. Agricultural land remains with the family.
Family, yes. There is also having a Marat driving license. Exhibit 29.
Who does not have it? Everybody has. These days, driving license is a.
Malay, no one will have Marat. He will have Lepi Marat. But he is also having a corporate tailor driving. And he has done Marat, it's a graduate.
Then, how do you establish his regular employment? How has 40% added to his future income? But there was no regular employment.
Your aspect, I will see there is only 32 years. But giving all these current qualifications, but the graduate is also skilled computer sciences from and done the course in.
All said and done, on the date of accident, he was not in employment anywhere.
On that date, he is not. But he would have been.
There was no employment as such.
He would have been done all these.
10,000 is fair enough.
It's a bigger about 32 years young, saving all these.
2014, with no proof of employment, if the tribunal has taken it as 10,000, how do you say it is on the lower side? Today it may look meager, but then in 2014 that is a reasonable figure. Okay, down the line after 10 years it seems to be a lower side. But 2014.
I did a skill in computer sciences by taking a course in NIIT, which is a reputed institution.
In spite of that, he could not get an employment. Shows how skillful he was.
You know, it's not that he came back to India due to some family problems. That's why for to find the go below.
That was the reason he was not interested in employment also.
It cannot be. Not interested, he would not have done all these things.
Otherwise, he would not have stayed there in Qatar only for 13 days.
So on the date of incident, he came back. But here to that, he used to go regularly. It's not that. He only came back after working 13 days. It's not the case. He used to go there. Rise on the date of accident.
That also is hard to accept for the reason that you have two passports, both of which are stood expired.
Yes.
If he was frequently moving from India to Qatar or any other countries, he would not have permitted his passport to expire. And even the renewed passport also has expired. That shows that it was not being used.
Even if it is not used, your Lakshmi kindly considers a graduate.
Merely having a degree, does that mean that he is employed? What is his potential?
His potential is that they acquired all these driving license and calculated as certificate course, computer sciences.
They have been granted 20,86,000.
Yes.
How many are the claimants?
6 million.
All
5 children.
3 children and parents. So there can be an enhancement of 40 to 5. Consortium only has been paid to first risk petitioner. Others have not been granted. They may get 2 lakhs can get enhanced there. Deduction was is it
For the state integration.
any chance of enhancing that?
No, that is not.
That's the only thing. 2 lakhs. These are 2 appeals assailing the order dated 11/3/2019 passed in
Your Lordship, kind permission.
Awesome.
The candidate concluding the lot with the instructions for also finally next week Miller. Finally Miller can be.
It has been finally adjourned for many times. That was
It did not reach to Miller.
so many times it has been given time.
Finally Miller. Kindly next week Miller.
The 2023 matter, you have not even complied the interim order granted by this court. How do you justify your action? Finally, we are hearing it finally today itself. And the experience that we have faced, every date of hearing, this is the only. The council would not appear in the first round. When we are about to pass an order, there will be a request made by the. This is the impression that we are carrying it all along. Make your submissions. There's hardly anything there. How do you justify your conduct?
The instructions.
What instructions, madam? You went to the department for an one-time settlement. They accepted to that. You did not honor that. You came to the High Court. We granted an interim protection. You did not honor. Coupled with the earlier assessment order itself, how long can you escape? What is the ground available? Tomorrow, at the request of the council, please not tomorrow, so and so for the question makes request for a last opportunity to request for last opportunity to address the tomorrow. Yes.
Let's appear on behalf of the appellant, Mulaj.
Minutes, I'm appearing on behalf of the respondents. I kindly request your lordship to kindly grant 3 weeks time on this minutes. The last time counter, we were instructed to file a counter, but the officers are slightly held up on election duty, Millets. They've requested for a little more time for giving the instructions.
Interim orders may be extended, Mulaj.
There were some interim orders. December 1st week or something, Millets, your lordship.
You were making a mention for this in the afternoon.
I'm sorry, Millets, because we thought it will reach.
No, was it?
Yes, same matter. Yes, sorry.
At the request of the council for the department.
It is set.
Yeah.
It is come up today for the confirmation of the order.
In terms of local shower.
I think that the insurance company has withdrawn that appeal.
The appeal is one preferred by the insurance company. Challenging the award dated 3/8/2015 in MBO.
That has 5A in all 5 cases. What is it? 5 is the right word. Just inform that.
5 or 4?
4.
Raise on the liquidation matter. If I complete petition. To provisional. If I complete petition.
What is left now? Company is gone in for liquidation. Yes. What is left? Where is the incomplete application? All the 4 petitions?
Yes.
The counsel for the petitioner submits that
For 71. May place correction. For the representative petition, appellate counsel membership are the matter. For the present appeal, file the concurrent filing.
You are appearing for the
appellate membership. The first respondent membership, the imposed penalty membership under section 112A, the Customs Act. The 20 lakhs membership imposed penalty based on the membership, the co-operative statement. The constantly without any recovery membership, they come to the conclusion and give the penalty. Allegation membership against the
who's on the other side?
other side.
You're the-
Allegation against the petitioner membership is so-called notice issued by the first respondent, page number 61. Come to the page number 61 membership very bullet. Permit me to read the allegation portion.
Page number
61. 25/6/2021.
There is a concurrent finding of fact.
Yes, sir.
Then what is the scope of interpretation?
I need several grounds for membership and also substantial question of law. Based on the confession statement, they come to the conclusion that they impose the penalties. That is the guardian law membership and supported the several Supreme Court judgment based on the Supreme Court judgment. Allegation against the petitioner.
Yes.
The so-called notice membership. Original of the page number 35, the portion of the again the petitioner, the page number 35, first two. Plus the graphic the intelligence officer director revenue intelligence Hyderabad, examined 4 quarters of the cargo imported Hyderabad by fighting of the S1 number 1, so 31, 2 and 2 from Sadar with the railway date. Bill numbers 1, so the cargo complex Hyderabad under the Panchanama dated important date membership the 31/12/2000. Based on the conflicting statement, as for the declared the 2001 diaries have no commercial value of the light of the 144 kg. The consummate of the cargo, the Abdul Jafar Dubai. UAE was the consumption of Abdul Jafar 18/10/2002. Keshav Chandrayana Hyderabad. Examination weight for the consignment was found to be 163.56 kg per ton. The hand diaries, and the books along with the diaries. For the 4 books, the shareholder the pocket like they were offered with the brown color. From the side the pocket for the container 9 transport the plastic cover containing 10 bolts bars of the 10 tulas each beside the bolt 10 tulas the key and the loose on the side of the plastic cover in the pocket. So the total from the foreign market the gold bar of the 10 tulas each of the total weight of 46.680 kg is value. It is the 2 crores 14,72,800 rupees found along with the 189 diaries and 5 books Arabic language. From the 4 quarters, similarly, the personally search. The Prasad family is a co-accused when actually very important. There is a confession statement based on the 2 co-accused. And Srinivas, we have conducted with the recovery from the telephone book, Vasavi Cooperative Bank Limited, duplicate passbook for the saving bank account number. So also the photograph is stamp deposit 7,500 paper chip. 7,500 minutes I deposited the 2 co-accused in favor of their bank account. And on the later then the Srinivas and one of the cotton scale group they threatened a small chip within the number. So also the telephone number bill dated indicating the call phone number. This is Prasad Ram Srinivas and Prasad admitted that they deleted the route recovered from them. being the brought by them, the facing the gold packet to the bodies, consulted to take up from the customs that they were the removing for the gold from the cargo packet as per the instruction of the Riyawati AK is the appellant well, so the appellant is the custom house agent, is registered the house custom agent. And nobody is around, they open the pocket and take the gold pocket their bodies and in the reality outside they put the 4 cotton along with the 40 gold biscuit here the seafood. But the only matters of the contention of the first respondent, the seafood from the matters to 2 is the name of the RTC temporary employees, the cargo transporter. It is registered customs house agent. The compulsory statement, even the statement voluntary confession statement, and page number the statement given by the co-officer against the appellant. Appellant give the 7,500 each 2 episodes 2 times. The allegation my lordship behind that 2 occasions my lordship dated 10/12/2020, 17/12/2020 and 22/12/2000. Last occasion my lordship the first respondent issued them to the some books and my lordship the search the 31/12/2000. The appellant house membership, nothing recovered from the appellant. The confection statement recorded in hand my lordship, page number 121. There's Prasad Rao, who is the co-accuser my lordship, and another one my lordship, the Muhammad Riyazuddin, page number 131. He is the appellant my lordship. Then my lord, the petitioner sent to the jail. On the subsequent petitioner, the file the and bail my lord, the regular bail way out. Then my lord, the appellant my lord, the TDI impose the TDI. This honorable court my lord, the satisfy the fee of the appellant is the release. Page number 211, my lordship, you kindly see it, the 211. This honorable court passed in the order, my lordship. After position of the order, my lordship, page number 227. Two eleven of the order population beginning and 227 the corporate position of the order. Additional year the replay may not so far okay without considering their replay, the state of they impose the punishment and same with the petitioner while the appeal may not they confirm the first respondent, then challenging the appeal may not the third respondent also confirm the same view, taking the same view. The concurrent filing may not be several ground raised the appellant my lordship in only based on the confession statement my lordship, they cannot take the view of the criminal and impose the penalty. My lordship, it's like article 20 class 3 my lordship, even though confession statement my lordship they go to the article 20 class 3 my permit to read my lordship. No person accused of any offense shall be compelled to be a witness against himself Plus, if they contest on the co-accused and also given the same duty, they taken the confession statement, impose the punishment. And when if the Indian Evidence Act also, section 24 to 30, age stated that the confession statement not a presumption of innocence to come to the conclusion to be drawn on the impose the punishment, penalty or any punishment. Based on this, at the time my lordship first responded, I made an application to examine cross-examine the witnesses. They are not allowed to the cross-examination of my lordship and also the appearance also my lordship they are not gone to the court. Only based on the Panchanama my lordship. Page number 31, the appealing order. Last 4 lines plus above bottom. The adjudicating authority rejecting the cross-examination on the ground that the right of the cross-examination is not the objective right. She has relied on the last number of the decision. So further, the adjudicating authority has observed that the loader, Satish Srinivas and Shata Prasad have not in the response to the so-called notice, or they have the appeal for the personal hearing. Relying upon this honorable Supreme Court judgment, the recent fellowship in this judgment, tax is different fellowship, the provision is a co-inclusive. In this case, fellowship tax
This is under Dada Act. This is under which act? Correct. Under which act has that judgment been passed?
This is the Dada Act.
Then how can you apply that under the?
That's the provision is under the act also, Indian Evidence Act, Indian Constitution Act, co-accused statement not based on
The principles laid down in the criminal jurisprudence is entirely different than the principles that are otherwise laid down under the revenue jurisdiction. That is not acceptable.
Raises several grounds for let's say based on the construction statement, permit me to the grounds and substantial question of law.
Yes.
Page number 9, my lordship, raise the grounds in the appeal, the concurrent filing. The order will counter to law in facts of the case. The order will explain the contrary law, all principles of concern law laid down by the law, the contrary to the evidence and material available on record. The first and third respondent have the grossly erroneous and not considering the whether the statement conflicts obtained the allegation under the section 108 of the Customs Act 1962. The respondent from the appellant and the two loaders are voluntary in the nature or not. The order of the impugn are in the gross violation of principles of natural justice, since they were the person without giving the applicant opportunity to cross-examination, examine the prosecution witness. In order the establishment he is concerned on and on the grounds along the liability certificate. Honorable the ability of the hold the order possible by the first respondent, failing to see the through the right of the cross-examination is not a guaranteed right under the provision of the Customs Act. It will be the setting the principles that when the reasonable case has made right out by the appellant showing the interest cause for recording the cross-examination, the first respondent have to be permitting the appellant to cross-examine witnesses. and the parent to the how to be allowed to appeal by way of the filing the answer. The Honorable Tribunal of Justice will grossly appreciating the evidence or material on record and failed to see that the entire evidence against the appellants is purely circumstantial in nature, and in the absence of the confession statement which are not corroborated by any other evidence, there is no case made out against the appellant. The Honorable Tribunal, the first respondent, how to be appreciate the contention of the appellant that the entire the guilt against the appellant based on the assumption of the presumption without any direct evidence linking the implicating the appellant to the any offences are charged by the super notice. The first respondent 26.2001. The first and third respondent have to appreciate the appellant in was in the no manner the connected with the side concerned was interpreted in the CC 31/2000 or any other three concerned which the stated we have with the framing the part of illegal public activities against the appellant. The other orders of the first and third respondent respectively grossly erroneously both based on the super notice issued by the investigation officer. DRI, if we have the deliberately supplies information pertaining to the concernment, despite how been the continuing forum made, watch parts of the modes of the opportunities are identical on the appellant's accusation, whether the co-accusation of the present case has been added as the sole accuser. The entire theory of the offensive allegation of the offensive DRI caused a hot expression of a very scrutiny system which are the elaborately in place in the customs bonded, whatever his allegation behind the preference of probability. The orders of the first and third respondent to present to one of the very fact investigating the DRI office have arrived at the Asmat Ali has a co-accused in the present case, where about the 10 to 40 kilo weight of the involving the operation has on the other hand. And the second case, which is the Anwar Ali was hired as the sole accuser. Was about the 220 kilos. We'll accept the page number 11, we'll accept the substantial question of law, we'll accept the grounds of the substantial question of law. Whether the order passed with the customs so on so the confirm the first respondent to things from the following calendar. Whether the individual present activity and the liability they have not been sustainable in the gross violation of the principles of natural justice, having the past without giving the appellant to fair opportunity to the establishing the innocence, they make out defense. Whether the correspondent could have the possible order impediment purely based on the evidence on the material or because the absence of the confession statement allegated under section 108, the Customs Act, whether the later confession statement could have the statement based on the conclusion of the guilty has was done the first and third respondent supported by the any other material evidence recovered based on the confession statement. Whether the Honorable Tribunal had come to the correct conclusion, there is a restriction for the confession based on the appellant was not admissible or proved and any taking of the same evidence without there being the corroborate evidence. Whether the Honorable Tribunal and the first respondent had to come to correct the conclusion is not concerning the allegation of voluntary statement to the order in relying so the call the confession without considering their reaction. So whether the Honorable Tribunal have been able to arrive the same the conclusion to appellate the guilty as a charge in the absence of the three reactions, the confession statement based on the other material and evidence available. Whether the Honorable Tribunal was correctly coming to the conclusion that the other evidence of the record is not circumstantial in the nature. The third respondent, the tribunal, the first respondent, hearing the evidence, refusing the appellant the permission, the cross-examination of the witnesses. Whether the first respondent being the adjudicating the authority and whether the third respondent, the tribunal had a rightly considered the appellant that wants to elaborate the security measure, the entire mode of the opportunity and the charge behind the preponderance of the probability. whether the first respondent being the adjudicating authority could not come to the different conclusion in the identical fact situation and hold that the applicant as an instrumental and eligible service following the rules and the allegation of the holding of the Mr. Hamad Ali is a sole attribute in the extraordinary situation, leading to the recovery of foreign made watch movement, especially when the both the modes are funded by the identical, whether the right of the granted by the Article 20 Class 3 of the Constitution of India, the violation of the respondent in the affording the appearance to be the witnesses against himself on the grounds of the statement obtained by the investigation authority during the time the appearance has been their custody was used without considering the respect to the side statement by the appellant. Page number 206 actually be requested to take them to the cross examination. That's what the request was not done. And he also given the representation to the respondent. Page number 293 for a moment we should be very important my perspective. Page number 293, last paragraph. It is expected to submitted to observation the basic and statement recorded under section 108 of the Customs Act and the stated the coercion of the officer case under section 155 of the Customs Act registered against there was made conviction under the threatened to dairy consequences that I got the told remove the on the 3 occasions yearly with the help of the site two loaders. In the effect, the entire case, however, the section 108 statement recorded from me and my material recovered from the persons of the site two loaders, which is to be particularly stands to me and the court of law. Section 1.
Penalty of only 20,000.
50 lakhs may have imposed the penalty to 20 lakhs. Appellant statement actually the appellant and other poor people, their amount is reduced. Other poor people amount 5 lakhs to 20,000.
Present appeal is by Mohammed Riaz.
Yes, it is appellant. It is the 50 lakhs penalty. This honorable court grant the conditional order. Suspension.
No, ठीक है. Perfect.
Customs Act minute should be 108 current for index for the power to summons person to give the evidence and produce the document. The section 108 will be free. But also they threatening the appellant and will be taking the evidence. That is not permissible. They are also the violation of the section 108 Customs Act. They come to the conclusion of the confection 311 chapter 14 section 311 confection improperly imported goods. They draw on the benefit they take in for 311 class B. Any goods which are the imported.
The order of confiscation has not been challenged. Order of confiscation.
Challenge confiscation order challenge. The penalty order is challenged.
Penalty after the confiscation has been done.
Yes. They present the
No.
page number 32, minutes, the operative position of the order. Criminal. Will also treat the permit to leave penalty.
Yes.
Summary, we have to find out there is a sufficient collaboration evidence come to the conclusion. We have been here in the affiliate, he is instrumental of smuggling the 400 foreign market gold bars issued on 31/12/2000 at Hyderabad airport. The finding that he is liable to the penalty under section 112A is correct. The seizure from the gold liable for the confiscation under section 111D, F, I, and J as held by the adjudicating authority. The confiscation of the 189 diaries and 5 books and also the 3 counts of consignment under section 118 and 119 of the Customs Act is up for because we confirm the imposing the penalty for 20 lakhs for the Mohammed Riyauddin Ahmed here in appellate. As per the load of the sanction of this involved, there is sufficient evidence to hold that he is a liability penalty under section 112A of the Customs Act. However, taking into the account in fact of the only the loader, we found that the penalty 5 lakhs on him be very harsh. We reduce the penalty him to 20,000. His appeal is disposal. Only recovered from the two loaders were also imposing the penalty. 4 members claims to be drawn on the page number 57. Only based on the confession statement and the judgment also confession statement, but the act is different. And this is the 2025 SST case 118, pain of 15 minutes. Let's on this.
Yes.
Page number 204 minutes. If they recovered the time 31/12/2000. Same date they given the confession statement.
What is this, page 204?
Annexed to the replay show cause notice the detail of the item to clips into that have been recovered. So from the two loaders on 31 to 2000. Collected from S. Prasad loader and from the S. Srinivas loader. The column of the what was recovered is white color, the cotton skin, rope fitted, cash deposited voucher, the counterfeit for the 7,500 into the account number. So on so 23 to 2000. And one small chip with so and so number, the telephone book directly personal. And Tata element bill card number, the telephone number during the call 716 minutes. Here the telephone book number, the Vasily Cooperative Bank Limited duplicate saving bank account, and formulating the bill from the treasurer pocket with the recovery. Next page, the annexure is the reply to the Shokar notice full allegation how we removed from the three cover consignment as per the statement of the loader and the three Muhammad Riyahuddin Ahmed. Here is the appellant. Plus three columns, the three columns where what is required the articles or documents. According to the statement 31 to 2000, the string was loaded at page number 3, para 3, Shokar notice. There were on 10 to 2000, their gold biscuit was removed for the complaint religious book in one quarter. And second one is 72 and 2000, the pocket was gold biscuit with the removed which put the complaint among the diaries for 2 quarters. The part of the gold biscuit pocket was handed over to Riyahuddin for the company in the 7,500 to the consignment. In the consignment, the arrived for the 22 by 2000, the identically two patterns. We carefully removed the pocket with the controlling to the person without the knowing of the customs, the ATST or the security. We went to the lower tangle and handed over to the gold biscuit to the pocket. We have the 7,500 for each of them. Second one is the statement given by the express of the another coepisode. We also see given the supporting the coepisode, and third one is the appellant statement. On the occasion of the 10 to 1 and 17 to 1 and 22 to 1, he got the gold consignment removing for the ATRC goes on with the help of the staples and the and handed over the pocket of the containing the gold of the person they mentioned it. Archie, he had the not personally confirmed the number of the gold biscuit. On 2 occasions, the person is not knowing to deliver the sum of 70,000 each occasion of the price. The RCB had not taken into the return the money. Out of the money to receive from the paid with the 10,000, the book loaded each on each occasion the different persons took the deliver. He does not know there is the actual name of the address of the on the third occasion. The consignment is the gold was the delivered in the Raniganj.
Please explain.
The depth of not having a clear. And also in the
No, what we were discussing was from the story, it appears that the present applicant seems to be an agent. Agent working in an air cargo complex.
Yes.
He must be facilitating in receiving and removing of the consignments coming from overseas out of the cargo complex. How do you establish the nexus that he has with the so-called smuggler? Goods belong to somebody else. He is an agent who may be interested with the job of
Statements recorded as one not
Okay,
in the Customs Act. The loaders and different persons. Only the judgment of the trial court.
When do we have it?
Thursday. I take out a xerox and
You have an extra copy?
it is not otherwise.
We have extra copy.
Court is also not having extra copy.
It's not yet.
I take out a xerox and go through. If it is not otherwise inconvenient, kindly have it next week otherwise Thursday.
Explain us the procedure also.
Yes.
How it works. Because if he is an agent, if he has been fastened with the liability of penalty, penalty can be only imposed against the person who has a nexus. In the capacity of an agent, what would have been his nexus?
An exam. Go through the statements and
What about those two loaders?
Yeah, also impose the penalty when I say 2 lower to 5 lakhs. Required to put 7 lakhs or 5 lakhs.
reduce to 20,000.
Only 1 lakh is also remaining of this is not any appeal not having of it.
Any other appeal is finally reached,
Cannot have it.
you will have to.
That's again, I test the client whenever there is no contact. Only
Maintain in office.
no other appeals, only we try the one appeal.
And that this client is also not responding.
If they give the opportunity to organize match, for you. I do some research class and organization.
Twenty-nine November.
Yes.
Give a copy to the other side. He is given. You can have a copy. Get a photocopy done in the.
Yes. We'll take out it.
So the land senior counsel appearing for the department. And
Make some requesting that for tomorrow morning. Some inconvenience, Ramakrishna Reddy is better. Tomorrow night.
who has to argue?
Please, for the part of the appellate has come in. We have comments in my opinion.
Please mention. No. It's part of it used to the same combination. As you release it. It's part heard, it has to be heard by the same combination. If we were in a different combination there, even if we have to release it from part heard, it has to be the same bench. There must be other matters also. If it is a write-up matter to someday afternoon, we can.
If that bench will come in.
No, not. We can constitute it on some particular day.
Yes, if you are just together.
Just give it to the week. Let the legislature judicial take an appropriate proceedings in. Okay. It is a part of matter. Yes, sir.
I can put a request to lots of standard next day. So they take the paper, they 60. What it has been just from the ground cost being below monetary inflation. And so far as safety is concerned, it seems to be a home.
Lordship, I'm appearing for the respondent in this matter. We have recently filed wakalat in this matter for the respondent, Lordship.
Yes.
Kindly post it to next Monday, Lordships.
Not even admitted.
We are not aware of that, Lord.
Should be explained.
Is it?
What is more matters what they are for everything from the question has changed.
When do we have it? Week after that. 28, 29.
Yes, Lordships.
Before 20th or
After 12. On 20th, you are here.
30th and 20th.
You are here.
19th.
19th, you are moving on. 17th, we'll have it.
Yes, Lordships.
It is a Friday. Then that will be a problem. 16th. The request of
Yes, Lordship.
this is on the 16th.
May it please your lordships. This is the matter where the lordships has to decide the date on which the capital gains tax payable on development agreement is leviable. If I could only request your lordship to adjourn the matter, because your lordship has already substantially a similar issue your lordship has reserved for orders in another combination. If your lordship could just have it after that, or if your lordship in the alternate says we have to argue, I'll make my submissions tomorrow, Malads.
But in the case where the finding is that the position has to be. Position was delivered to the developer. That is the categorical finding. That is the development agreement. Also categorical state.
Which is that appeal that we have heard?
This is the matter which you have heard here, but it was not marked as part heard or anything, Malads. This is only the matter in which I had made submissions, Malads.
You say that there is one matter where the orders are reserved and likely to be.
Malads, 5194 of 2020, that is in GST, Malads, but that would have a bearing on this as my submission, Malads.
5194
of 2020. It's reserved for judgment, Malads. Malads, in that there was an issue when the transfer of land takes place for the purpose of levy of GST.
Development agreement.
Yes, Malads. 5493, Malads.
5493
of 2020. Malads, prior to the Dashera vacation, your lordships had reserved it for orders, Malads. My only request is if this could be taken up a little later, because that would have bearing on this, Malads. Or if your lordship says I have to argue, Malads may take it up tomorrow, I'll argue the matter.
If we ordered it before the Dashera vacation, we'll pronounce the judgment after the Diwali vacation.
Malads.
Yes, let's see.
That's because the issues, a lot of questions in this may be answered by virtue of that judgment, Malads. That is the reason I'm requesting.
Yes, we'll have it. When do we have it? First week of December? But you are not there.
Second, after second.
You are not there till 12.
Yes.
14th? 14th of December, at the request of the council to the parties. For the hearing.
The SSC code is the Andhra Pradesh State Electricity Board. Therefore, very soon with the was not taken up by the tribunal. On the ground that it required the clearance from high-power committee. The subsequent Supreme Court judgment said that it not be referred to high-power committee and their protest revenues were enabled to file a issue advance. But however, since it is Andhra Pradesh State Electricity Board, like to get some instructions not as to whether this should be the SSC is here, the listing officer is here in Andhra Pradesh. it needs to be transferred to the High Court of Bangalore.
It has been rejected in the light of some earlier decision also.
Yes. That is earlier, not even the observation of the Honorable Supreme Court that in all cases where not the governmental institutions are involved, but there should be a committee which sits together and then decide whether the appeal should be filed against a person. Subsequent to Supreme Court judgment, where they said to be as these were never formed and never took place, and matters were being disposed of by the tribunal without any committee which formed them, or the appeal getting stranded in that manner. Therefore, not subsequently Supreme Court has informed. But it's not required. But the fact that whether or not it has to do before the Eastern Airport.
The judgment of the Supreme Court also has much subsequent. On the date when this order was passed,
yes,
it was proper.
That is true, but there is no committee at all. Because only advisory, that's why the grounds, what we have raised here is this, in the case. The grounds is the large. Whether the principle of clearance from the committee involved in the Supreme Court, the applicable to disputes arising between the inspector and the undertaking owned by the state part. But ultimately, even the case one matter, we along with undertaking also is enough.
Why, according to you, this court would not have the jurisdiction?
But since not the SSC officer probably didn't.
Assessing officer is again range 1 Hyderabad.
Yeah. The commissioner is possible.
The thing is, the respondent has now changed.
That's what I've led with instruction going for a very old matter. And in fact, I think the number of cases not of AP Housing Board as well as AP Housing Board, you have to put but LHC Board itself, but some other undertakings, not at least are there. Try to get instructions.
But this is from range 1.
This is range 1.
Therefore, it would be this High Court only. Only thing is, the status of the respondent has now changed.
Yes,
it has got converted into many other companies now.
The exact position not as that. There was a division. We took
division of the two companies, two boards first, and then each board has subsequently been converted into different companies. When?
Lakshman in January, not very.
Taking into consideration the subsequent development that are taking place subsequent to the filing of the appeal. You are appealing for next month.
Before, by,
Agenda class Patman will kind of 2 weeks time. Unless surgery not facing.
You are there.
Agenda class Patman.
We'll try to.
Unless surgery not facing.
No, you are there. We will record your presence and go appeal by the claimants for enhancement. We're also on the same board.
Due to some personal inconvenience, Ramakrishna Reddy is left. I just want also recall. Anytime, we are ready next week. We are appearing for the insurance company in all 3 matters.
Correct. No, it's an appeal. What reflected is it's an appeal of 2006.
Finally,
Next week,
Surgery not facing.
you are there. We will. Your presence is sufficient. Let her take rest. We will ensure that you protect her interest in the best manner. The 2006 matters, how long can we adjourn? The new matter we could have definitely given you January, February invoice. '28th, 29th.
28.
84 to 86 on the ground of the arguing council being not well. '29.
It's highly covered by edition of the sound before. My friend, tomorrow,
If it is covered, Mr. Prasad can also help us.
yes. The TDS.
What is the issue?
TDS joint venture, individually TDS may, whether they are applicable or not, the question that was not considered by the SM office. It was prepared to put some people. Among the joint venture partners, who has also the same position, but he succeeded now the first appellate authority, second appellate authority, even before the Honorable.
This is that order.
That is the. He is one among the other joint venture.
In respect of the same assessment?
Yeah, not same.
Same assessment here.
Same assessment here. Yes.
Same assessment.
Yes.
Here also it is 4 and 5.
Yes. He has succeeded in all the authorities before the department, even before the tribunal.
Then how is it that in this case the authorities took a different view?
Not a weak note, not a deep submissions are like to bring to a kind of thing.
No, no. What I'm asking is if in that case, in the case of this petitioner, whose judgment stands decided by this court, if the authorities are taking the same view, why was there a difference in the present one?
Yes, I am one among them. Oh,
no, why not a same view by the authorities?
I have a question here in the petition. The action of the assessing officer. Let's make my summary. Let's make
referring to his own view. Referring to his own.
He rejected my claim to grant TDS. Merit is now 14/11/2005 by letter dated so. Questioning that merit, the present petition. If not merit, I prepared instruction. The actual aspect of the case is the collaboration agreement was entered into only 2003 by the petitioner and three other relating to the laying out pipeline of so on, so on. So the names of the parties who are the signatories to the agreement are Giant Chandra. The one is Sahara, who is a C before lordships, Koya and Company, the Indian Youth Pipes Limited, Muratham and Company. But all terms of the parties are set out in the agreement. The same is applicable to all of them. Point number 8. The work carried out by each party is independent of the other. Each of them have different work to exclude and amount paid to them is independent of the other. None of four parties have any connection with the work to be done by the other. The profit earned by them is also independent of each other and belongs to the respective person who has done the work. The agreement for collaboration and cooperation is only for the purpose of winning the tender and standing a better chance for the equalification. All the four parties are separately assessed to tax. The income tax particulars are as follows here. Each party. But the Hyderabad Metro Water Supply Sewerage Board was making the payment to the parties respective works executed by each of them. Currently, whatever TDS I have been issued by the authority, but I have a question to grant me the payment basing on the TDS setting. That was rejected by the other. That is the point.
the single issue, my lord, they have sold 357 ITR, 396 of December military 18. Page number 203, 11 pages, 402. Statement I gave. How? Page number 402. It starts from 396 million.
Bhuratnam.
Yes. Sometimes rules 2011, the Central Code of Direct Taxes amended rule 37BA and sub rule few of class notes, so three such where the provisions of the act, the whole or any part of the income on which tax has been directed. Source is accessible in the hands of a person other than the directing. Credit for the whole or any part of the tax directed so as the case may be, shall be given to the other person and not to the directee. This amendment has done away with the specified four clauses in the re-amendment rule 37BA, which restricted the benefit of the rule only in four specified situations. It has thus widened the scope of rule 37BA, hereby enabling the credit of taxes to the actual paying whose acts the income is accessible and not restricting this benefit only in specified four situations. Now, the Commissioner of Income Tax and the tribunal have rightly held that C is entitled to the rate of TDS mentioned in the TDS certificates issued by the contractor, whether the said certificate is issued in the name of joint venture or in the name of a director of the SSC company. They have considered the terms of the agreement dated notes among the parties to the joint venture and held that rate of for TDS certificates cannot be denied to the SSC by assessing the contract receipts mentioned in the said certificates as income of the SC. The income shown in the TDS certificate as either to be taxed in the hands of the joint venture or in the hands of the individual or joint venture. As the joint venture has not paid enough income and claimed credit for TDS certificate, and the TDS certificates have not been elected, rate has to be granted to the TDS mentioned therein for the SC. And the revenue cannot be allowed to retain the tax deducted source the last before pay of the 403 without rate being available to anybody. The rate of tax is not allowed to the SSC and the joint venture has not paid the return of income. Then rate of the TDS cannot be taken by anybody. This is not the strict and intentional law. It will now be classing officer able to name the TDS mentioned the TDS certificates filed by the SSC. Known that the TDS certificate is issued in the name of joint venture or a director. Yes.
my lords, may kindly see the letter issued to the assembly officer, page number 19. Editor.
Yes, Mr. Prasad, what do you say?
What you are expecting, and this order will be the speed.
Issue seems to have been decided by the High Court.
Right. This will not. Can come to the I don't have the page for it. I live in Alberta. I will provide it. No, I don't.
And you spoke to Ms. Mamta.
I did not.
So if she is
That's why I
aware,
asked tomorrow, because my grandson said, I mean, I know this message of the basic is some distribution. Lakshman, I thought, okay.
let the matter be taken up on the 14th of. Next is also same.
That's a power matter. By assist one case for all the previous periods of signal.
This it is Mr. Prasad.
Yes.
This is covered.
Yes. The only question involved is
Admitted appeals.
the repetition. She was That's my kind of page number 15.
Page number
15. The assessment order itself question.
One.
Repetition.
1-5.
Yes. For the assessment year 2001.
Yes.
So we can pay a lot of but the all other years of the SC, they were considered as a treatment. And that's to operate the practice. Still carrying on the data state, right? So it's not income. And the still have to go to the 200 to go to 58 tax will come out.
The original income was also 42. His main source income is rental income from property. And flight out to the next of 30 lakhs, 27 crores expenses under the act. Interest. Partner by creating the partner capital into two accounts. The partner capital account and the partners, which is not allowable deduction may be had income from house property. The sixth case has been reopened invoking the rules of 47 of the text of the 33. According to notice and section 48, also serve on the response to the get notice. The CY is letter dated so filed requested to pay the return of income already filed. Response to the said notice. Response to the notice issued to RC after recommendation and appeared from appeared from time the RC has writing information added in the file. The verification of the information file reference to the return of income and after discussion of the case with the CCA, the assessment has been completed and has been stated the C claim business towards expenses under the act just on partner loan by bifurcating the partner to two accounts. Partner capital account and partner's loan account, which is not allowed to deduction under the act income from house property. The reason for the reassessment year, for the assessment year 2001-2, also the SC claimed the deductions, which however was disallowed by the then assessing officer and added to the income returned after the elaborate discussion made in the assessment office. Relying on various judicial constraints and misuse the case laws. So, not basically, he says that based on the earlier order, against the CIT order, they have resolved, but against the tribunal, the tribunal order, but revenue has not contested the before this order before.
They say that
become final.
They said in paragraph page 16, though the ITAT has deleted the addition, the revenue has not accepted the decision of the ITAT and has preferred an appeal in the High Court.
Yes,
which is that appeal?
They don't have any material, but following this 2000-2001, that is previous year is the earlier 2001-2, that is their contention. This honorable tribunal, they went under the court, questioning the ITAT order. As such, there is no any material to the body. Following that, I have found the paper book wherein I have shown for all the years, subsequent years. This was considered by the tribunal.
And in none of the matter, it has travelled to the Supreme High Court.
Yes, that is the case. Madam Chancellor. All the other years. The tribunal allowed the appeal. Which means as the partnership form.
The appeal was allowed at the
ITAT.
ITAT. Reversing the order of the CIT appeal.
Yes. Last may kindly see that I have memo I have filed. Wherein I have instructed. Even recently on 25th May 2023, for the tax period assessment years in that 2017-18 and 18-19. And earlier, 232, 34 and 4. That's my kind of saying. The memo in which I have filed the orders of the ITAT in my own case.
We close it. But why was a writ petition filed? It could have been by way of an appeal also.
No. It was because year for the year this year was admitted the petition then. But all other years were. The contestation was at the time, whereas the ITAT order, there was no second appeal before this honorable. So
then
in that ground, we have to whatever order passed by the tribunal, which is binding on the single officer, without considering the condition of the state, not the single officer confirmed the proposals. Was my condition. That's why it was.
Can you just make that submission again? Why that point of time there was no provision of an appeal?
But it is probably was it. In fact, I don't know if the complaint is filed in this case. We might have taken the stand to appeal or nothing. The superior authority of tribunal order is a binding on the single duty bound to follow. It was not followed, then we approve this.
No. Why not by way of an appeal?
Actually, as he was advising, because of the questioning the assistant officers, the purely violation of principles of national is binding on nature. So mentioned that passing an order. In that, in respect of all the subsequent years, the find a pension.
Challenge in the present petition is to the order passed by the ITAT. Ask me the first respondent on the section. Page number 13.
It's put on 1.2 blood, not the first very activity.
No, page number 13, your relief in the writ petition.
Yes.
Relief clause.
Yes. These are bloods. Rare.
Rate that is honorable court pleased to issue the writ of mandamus.
Yes, yes. And these are
The respondents.
the action. Passing the order based on section 1.6. Taking the income of the house property by reserving the claim of jurisdiction.
So this was.
Yes, actually, it's not reserving the.
This is treating the income of the house property. Not the income.
No. Just not income from house property. First we trying to see assessment of it. There is the interest from the house property, but they have rented out from the is their property, against which the rental income received. But they just because the assessment order cannot be set aside. So far as the interest is concerned, what is this problem is correct. The 27/1/2006 order is an assessment order. Here this allowance was made. The full order as such cannot be. The issue is the only. It's the only issue. Yes.
Whereby the petition is claimed for.
Should claim famous partners who own on or result as direction. So kind of heading number 16
on partner was disallowed by the city, which was subsequently satisfied by the tribunal in all the subsequent assessment years. Subsequently, the petitioner has brought on record few of the orders passed by the ITAT in respect of the SC himself for the subsequent years 2002-3, 2003-4, 2004-5. Also, in respect of the assessment year 2017-18, 18-19. in the aforesaid record orders pertaining to the petitioner for the subsequent assessments. Petition law.
I also confirm the petition side. The petitioner was a proprietor of Purna Wines, running of Cherry Street, Vijayawada, and assessee on the file of second respondent. A petitioner agreed by the impugned order proceeding of the Commissioner of Income Tax Board, Hyderabad, on dated 25/1/2006 is in reference with the purported issued under 119 of the Indian Income Tax Act 1961 is then this is why this writ petition is being filed. But tax return filing had to be done before 30/6/1993. Is on the page 8, para 1. However, the tax return was filed on 28/2/1996 after 2.5 years. Well, also the reasons are different. I mean, there was a huge hardship which are offered to the customer. All of a sudden, government has cancelled license, shop license, and the government has also all of a sudden shut down its wine shop. So that was the only source of income to the petitioner, and all of a sudden it was shut it down. However, he has already been paid his all the taxes regularly. He was having advance tax paid already with the department. And all of a sudden this hardship has happened to him, and he was undergone through different diseases, like he was completely bed rest for jaundice. Afterwards, he has suffered from paralysis attack, which is been I mean, he has already submitted it on the page number 8 and page number 36. I mean, the returns, whatever he used to pay regularly prior to this. And he was also having an excess refund amount, which was there with the department, which was 1,66,093 rupees. My lords, he was when he came back after 2.5 years, and he has already been to the different places like second respondent. He has already communicated different merits, right? I mean, in person he has went there, but they didn't entertain him. So he has written different letters also. The petitioner has requested refund amount several times in person, but no one has responded. He has written letter on 21/1/2005, which is on page 34. Wherein he has already specifically asked to refund his amount since he was going with the financial crisis, and the amount was lesser than what he has already paid as in advance.
No. If you look at the order, you had filed the returns on 20th of February 96.
Yep.
Then you have moved the application for condonation of delay after 10 years. 21/1/05.
Because in between this, I mean, he was having so many of
10 years.
He has been through with different medical problems.
For 10 years?
Yes, madam.
What is the proof?
When it's been given to us in written that he was having that paralysis effect.
Correct, but which has not been accepted by the commissioner. You have filed this petition in 2006. Even in 2006, when you filed the petition, it is not supported with the proof of the medical treatments that the petitioner has undergone.
So I believe he has in person given the same, I mean, all the medical things to the second respondent, what he has spoken with us on my communication. However,
these are not on records.
Yeah.
So we cannot
not
accept that.
I mean, it is my humble request to just see the which are having the same facts, same hardship, and situation is also the same. So I have seen the same petition. I request to see para 8. Or prior to that, I would read para 2 and 3 also. During the para 2, during the assessment year 2016-17, the petitioner paid tax amount of rupees so and so, which is also reflected from Form 26 AS. Petitioner filed its return of income belated on so and so date under section 139 subsection 4 of the Income Tax Act 1961. The due date for filing the income tax was return was September so and so. The time to file income tax return had been extended up to 17 October 2016. Hence, there was a delay of so and so 43 days in filing the income tax. So, I mean, the days are lesser, but if you see the facts in the third paragraph, fourth, fifth, and the last slide, I will not go into much detail. I will read out the 8 paragraphs. The court has held that the phrases on genuine hardship should be considered liberally, particularly when the legislature had compared the power to condemn the delay to enable the authorities to do substantive justice to the parties.
Can you compare a delay of 43 days with a delay of 10 years?
My lordship, he was having a very hard.
Where are all those materials?
He would. I mean, it is my humble submission, my lordship. If you see, there are only 2 things which I want to mention or we want to submit. First is the show cause notice itself was not given, not served to the petitioner, and if it is given, where it is not there.
We are not testing the merits of the case.
He was, I mean, there was a huge problem all of a sudden occurred to his firm, and it was there for a number of years. It has, I mean, AP government has taken over all the wine shops under their own, they have taken by the private owners, and they are operating by their own. So it took little longer years for him to go and follow all the things. And after that, when he was affected badly. So I humbly submit that please consider his hardship and condone the delay. Secondly, my lordship, if you see the input order itself is a vague input order. Please see the page number 20 of the same input order. However, I can understand, my lordship, the amount itself was very lesser. But what they say is, the authority says is, the assessee claimed that the delay was on account of illness of his accountant also. At that time, he was also not feeling well. However, no proof of illness of his accountant is submitted. Further, the accounts were finalized on so and so date under section 44 AB of the Income Tax Act. As per the covering letter of chartered accountant on dated so and so, although the report was not enclosed. Now, my lordship, see the word what he is saying. The income shown by the assessee is also very low, keeping in the view of the turnover, thereby claiming a heavy refund of tax, heavy refund of advance tax. I can understand that though the amount is lesser, if you see the gross, I mean the income itself, it is lesser than 4 lakhs. The person who is earning lesser than 4 lakhs, it is very difficult for him in that circumstances to survive.
How do you justify the delay of 10 years?
Only we can only submit. My lordship, he was undergone with different, his medical.
That was not the ground raised there. There you have said that the accountant was not well.
So that time when he came back after certain duration, when he has filed different letters also, that time he was having some problem with the accountant's health. It has been prolonged, and after that he was not able to follow up with it.
Difficult to even exercise the discretionary powers. So unreasonable period of delay.
One last, my humble submission is, my lordship, if this amount, whatever amount is left within our department, advance tax would have been given to them back. That itself he would have given the same amount. It could have not came after 10 years also. Till now he has having a number of problems for his own survival.
The entire exercise at this belated stage has been done only for the purpose of getting the refund of advance.
Lordship, that is the only amount he has.
But then that should have been done within a reasonable period of time.
His contention is he has also several times asked to the department that whatever the amount is left, he is about to pay. He is accountable, he is liable to pay, can be deducted from that amount. So he has never said that he will not be paying that amount. He only said that whatever amount is there with the department has to be taken, considered, and the liabilities has to be clear.
Challenging the present petition is to the order dated 25/1/2006 passed by the first respondent. Insurance is 8% for the. Yes.